And with that, let's get to the very latest on Oregon's Measure 114. That is the voter-approved initiative that would ban future purchases of so-called large-capacity magazines that carry more than 10 rounds of ammunition and require a permit for gun purchases. So on Friday, U.S. District Judge Karen Immut issued a 122-page opinion that upheld Measure 114 and said that both elements of the law are constitutional. Her ruling came after a week-long trial last month. Now, according to the Oregonian, the gun rights groups involved in the lawsuit have already now filed an appeal as expected. Though, before we get ahead of ourselves, let's take a look at this most recent ruling because it is the first comprehensive decision on Measure 114 from a federal standpoint. The trial itself focused mostly on the large capacity magazine element of 114. The at issue, of course, here, the Second Amendment. Plaintiffs here, the gun groups challenging it, say limiting magazine sizes violate that constitutional right. In her opinion, the judge wrote the Second Amendment protects an individual's right to self-defense inside and outside the home. But large capacity magazines are not commonly used for self-defense and therefore not protected by the Second Amendment. We're going to get into it here. She cited an expert that defendants, the state, called during the trial, who analyzed years worth of data to prove that very point. Okay, Lucy Allen is the senior managing director for NERA, or the National Economic Research Associates. They are a consulting firm for the public and private sectors. Allen used an NRA database on defensive gun use situations to look at more than 6 years of self-defense incidents between 2011 and 2017. We're going to get to the numbers. There were 736 total incidents. 18% involved 0 shots fired. For 80% of the incidents, it was 1 to 5 shots. 13, less than 2%. 6 to 10 shots were fired, and just twice were more than 10 shots. That represents 0.3% of incidents, more than 10 shots fired. The overarching average number of shots fired, you see it in the middle of your screen here. These are defensive gun use encounters. Again, according to the NRA database, 2.2. All right, Judge Immut went further here on the Second Amendment not applying to large capacity magazines because she says those magazines are not necessary to make a firearm work. Quote, a firearm is not useless without a large capacity magazine because magazine capacity is not a determining factor in the operability of a firearm. And the right to bear arms does not become meaningless because the government chooses to restrict large capacity magazines. The judge said even if the gun groups could have proven the Second Amendment protects large capacity magazines, Oregon's restrictions are consistent with a history of firearm regulations. So, in her opinion, it may not have mattered. The same goes here for the permit to purchase element of 114. We'll get into that now. She wrote that both elements are keeping with the nation's history and tradition of regulating uniquely dangerous features of weapons and firearms to protect public safety. All right, you can imagine that gun groups who are suing to stop Measure 114 were not happy with Friday's ruling. The Oregon Firearms Federation is confident the case will swing in their favor in the Court of Appeals. But they also blasted Judge Immut, calling her ruling simple nonsense and absurd. They went even further. They called the judge painfully ignorant and in the pocket of Oregon's far-left Department of Justice. I'll just point out this is federal court, right? Okay, clearly the Firearms Federation is not a fan of the judge. Many of you are probably sitting at home thinking she was appointed to her seat maybe by a Democrat. No. Former President Donald Trump appointed Immut in 2018. Her appointment was confirmed, yes, by the U.S. Senate with support from both Oregon senators, Democrats Ron Wyden and Jeff Merkley. Bottom line here, what does Friday's ruling mean for the implementation of Measure 114? And the answer is nothing for now, because the law is on hold because of the state court ruling in Harney County. In that case, we have to wait for a trial in September, to say nothing of appeals, presumably, at both the state and federal levels. Stay tuned, as we say.